Good morning, and welcome to our Rapid Response webinar on the Fifth Circuit ruling on the Affordable Care Act. I am Sarah Dash, President and CEO at the Alliance for Health Policy, and I will be moderating today's discussion. For those who are not familiar with the Alliance, we are a nonpartisan organization dedicated to advancing knowledge and understanding of health policy issues. We do not lobby, advocate, or take any policy or political positions ourselves. Instead, our mission is to educate the health policy community. It was a year ago to the day that we had our last Rapid Response webinar on this Affordable Care Act case and the individual mandate's constitutionality. That one looked at the ruling from the District Court for the Northern District of Texas. That 2018 ruling was appealed to the next level of the courts. And as you know, last night, the Fifth Circuit released its long-awaited ruling. Today, we will be discussing what this ruling means and what we might see in the coming weeks and months from the courts, Congress, and the healthcare market. We have some fantastic speakers who I will introduce in a moment and who have no doubt had a late night analyzing the ruling and its potential implications. Before we begin, the Alliance for Health Policy gratefully acknowledges the National Institute for Healthcare Management Foundation for supporting the Beyond the Beltway Health Webinars for Journalists series. We would also like to thank the Association of Healthcare Journalists for their help in shaping this series. If you are interested in joining the Twitter conversation, use the hashtag AllHealthLive and follow us at AllHealthPolicy. I'm going to briefly orient you all to the GoToWebinar platform and quickly review some technical notes. You now see a screenshot of the attendee interface. You should see something that looks like this on your computer desktop in the upper right-hand corner. You can click the orange arrow to minimize and maximize this menu. When you joined today's webinar, you were muted, and you will be throughout the presentation. Please use the question panel to chat with us about any technical issues you may be experiencing. You may also send in questions that you have for the panelists at any time. We will collect these and address them during the broadcast. Here is our agenda for today. Each of our panelists will make some brief opening remarks, and then the bulk of the rest of our 45 minutes together will be on Q&A so that we can make sure to tailor this to what you all want to know. Again, please submit questions using the question section in the audience interface at any time during the webinar. You will also find all of the materials that accompany this webinar, including speaker bios, a resource list, and an experts list on our website, allhealthpolicy.org. And a recording of today's webinar will be made available immediately following the webinar. Now, I have the pleasure of introducing our panelists. Katie Keith is an adjunct professor at the Georgetown University Law Center, where she teaches courses on the Affordable Care Act and LGBT health law and policy. She also has a part-time appointment at Georgetown University's Center on Health Insurance Reforms and maintains a Following the ACA Rapid Response Analysis for Health Affairs blog. Rodney Whitlock is currently Vice President of McDermott Plus Consulting. He has more than 20 years of experience working in the U.S. Congress, where he worked as a health policy advisor for the Finance Committee Chairman Grassley, former Representative Charlie Norwood, and then for Senator Grassley's personal office. First, I will turn it over to Katie to outline some of the legal aspects of this case, including key moments leading up to yesterday's ruling and what the next steps in the courts might be. Katie, please go ahead.
Thank you, Sarah, and happy Thursday to everyone. Thank you for having me. I actually didn't realize it was exactly 1 year since we did this before, so it seems like this will be an annual event that we can all join. So I will try to keep my overview fairly brief, and I'm going to focus on some of the legal questions and exactly what the Fifth Circuit said, but very happy to get into questions that folks might have. So I'll start with a little bit of sort of brief background on how we got to the Fifth Circuit in the first place. So this lawsuit, Texas v. United States, was filed in 2018 by 20 Republican attorneys general and governors, later joined by 2 individuals in Texas and ultimately the Trump administration. The plaintiffs want to revisit the Supreme Court's 2012 decision in NFIB, where the court ruled that the individual mandate could not be upheld under the Commerce Clause, but could be upheld under Congress's taxing power. The plaintiffs want to revisit NFIB after Congress reduced the individual mandate penalty to $0 beginning in 2019. That change, as most folks remember, was made in the Tax Cuts and Jobs Act in December 2017. The plaintiffs argued that the mandate without a penalty can no longer be upheld under Congress's taxing power under NFIB. Because the mandate is so critical and essential to the rest of the ACA, they asked that the entire law be struck down, alongside the mandate. Folks are probably familiar. We have Democratic attorneys general led by California that intervened in the case to defend the ACA. And last December, as Sarah mentioned, Judge OConnor of the Northern District of Texas issued a sweeping decision agreeing with the plaintiff. That decision was widely criticized by conservative legal scholars, the editorial boards, the Wall Street Journal, National Review, and many others. In that ruling, he held that the mandate is unconstitutional and that the entire ACA is invalid. That decision was quickly appealed to the Fifth Circuit Court of Appeals, which is widely regarded as the most conservative appellate court in the country. The 2018 midterm elections brought some changes as states joined or withdrew from the lawsuit, and as it stands now before the Fifth Circuit, there are currently 18 Republican attorney general or governors, 2 individuals in Texas, and the Trump administration on one side are all arguing against the validity of the ACA. And the ACA on the other side is being defended by now 21 Democratic attorneys general and the U.S. House of Representatives, which intervened earlier this year. So there's 5 groups of parties, which means that things get procedurally complex very quickly, something to sort of keep an eye on, and that certainly comes across in the Fifth Circuit's ruling. So as most folks know, oral arguments were held at the Fifth Circuit in July, and they issued their ruling yesterday. The 3-judge panel issued a split decision, a 2-to-1 decision. The panel's 2 Republican-appointed judges partially agreed with Judge OConnor and the plaintiff. The other judge, a Carter appointee, issued a lengthy dissent that is worth a read if you get a chance. The Fifth Circuit really focused on 4 questions. The first question is whether the court had jurisdiction to hear the case in the first place. Second, whether the individual and state plaintiffs have standing to sue. Third, whether the mandate is now unconstitutional. And fourth, whether other parts of the ACA should be struck down alongside the mandate, which is essentially whether the mandate is severable from the rest of the ACA or not. For timing purposes, I'll sort of set aside those first 2 issues on jurisdiction and standing, but would be happy to answer questions on those. Jumping right in on the constitutionality of the mandate, the Fifth Circuit again agreed with the plaintiff and Judge OConnor that the penaltyless mandate is unconstitutional because it can no longer be read as a tax under NFIB. The Fifth Circuit pretty much adopted Judge OConnor's rationale and really looked to the Chief Justice John Roberts and the dissent in NFIB to reach that conclusion. And what is sort of the biggest wrinkle in terms of next steps, and what I know I'm getting a lot of questions about, is that the Fifth Circuit remanded the case back to Judge OConnor for additional analysis on severability. So the Fifth Circuit notes 2 reasons for why it's sending the case back down to Judge OConnor. The first is that they were quite critical of O'Connor's severability analysis in his decision from last year. They referred to it as incomplete, and they used a couple other choice phrases, if you will. They sort of sent it back to him and asked him to redo the analysis using a finer toothed comb, is how they put it. They did not have kind of enough to go on as the conclusion that the majority reached. The second reason they remanded is to consider the Trump administration's many changing new positions on severability. So while the case was being appealed to the Fifth Circuit, the Trump administration changed its position not once but 3 times during the appeal, and that introduced a lot of confusion for the court and the other parties, and a significant reason or justification for why the Fifth Circuit is sending the case back down is the confusing positions taken by the Trump administration on appeal. I do want to emphasize that even on remand, nothing prevents Judge OConnor from issuing a ruling that's just as sweeping. The Fifth Circuit really just suggests he needs to explain his decision better. They also pointed to some parts of his current analysis, particularly on the protections for people with pre-existing conditions, as strong. They sort of looked at his analysis of severability for guaranteed issue and community rating and referred to that part of the analysis as cogent. To me, that suggests that the Fifth Circuit might be likely to agree that at least some parts of the rest of the ACA are invalid. We just don't know how much yet. And then in terms of next steps, I'll sort of wrap up with timing here and turn things over to Rodney. But the California Attorney General, Becerra, has already announced he'll appeal the decision to the Supreme Court. The Supreme Court does not have to accept the appeal. If it does, the fact that the decision came in sort of mid to late December makes it less likely for the case to be heard this term. But the court has very broad discretion, and they could allow for expedited briefing if they think there's an urgent reason for this case to come up on appeal quickly and potentially have a decision by June 2020. The Supreme Court could also accept the appeal for the next term, which would, begin in October of 2020 and sort of extend through 2021. If the Supreme Court declines to hear the appeal, the case will continue before Judge O'Connor. He's been directed by the Fifth Circuit to go kind of provision by provision of the ACA and determine what is severable and what is not, based on how essential it is to the individual mandate. Even while that was happening, the ACA would remain the law of the land in the meantime, just as it is now. But again, I would emphasize remand is going to mean many more years of litigation. We would have to wait for a new district court decision from Judge O'Connor, another appeal to the Fifth Circuit, and then an eventual return to the Supreme Court. In my opinion, I think more litigation most certainly means more uncertainty for the healthcare system and continued confusion for industry, for state and federal officials, and for patients. So I'll stop there and either turn it back to you, Sarah, or over to you, Rodney.
Thank you, Katie. That was a really great overview. So I will turn it over to Rodney for some of your thoughts, and then we'll get into a Q&A.
And thank you, Katie. That really was excellent. And for those of us who are still trying to figure out what the heck is going on around here, I, like many of you, was not expecting this. I was actually driving and on the phone with a staffer when he said to me, "Oh, great, Texas versus Azars out." I'm like, "Oh, come on." And I know many of you were looking at your Wednesday nights going, "How did this happen?" But so we dig in and figure it out. So I'm going to talk about the dirty, nasty side of the world that we call politics and what to expect moving forward. If you're not reading Nicholas Bagley, you're doing this wrong. He's got some really great thoughts out there, but I'm going to take a risk and cross him just a little bit and say this right now, which is, while one cannot look at this decision and go, "Oh, great, everything is peachy keen and the ACA continues," clearly not. But you do have to look at it in the terms of the context of, okay, what is real and now, both in terms of the policy and the politics. So for the policy, the Affordable Care Act continues to exist. And we need to be reminded constantly that typically through the tortured life and times of the Affordable Care Act, it generally involves the Supreme Court before actions are real. So if you go to the NFIB versus Sebelius case, King versus Burwell, the Hobby Lobby case, it's only when the Supreme Court has puts its imprimatur on things that it becomes real. The Fifth Circuit, the Fifth District, again, none of us, I think, ever, and listen, I'm not a lawyer, so I'm being very careful with my participation in my own appropriate lane, but I don't think any of us were expecting a decision that, for example, made biologic drugs go away in the Fifth Circuit or something crazy like that. I think what we were expecting, or at least I think would have been more critical for the political world, was if the Fifth Circuit had said in whole they agree with the Fifth District decision, as if to say that the Affordable Care Act should be held incompletely, in its complete sense, unconstitutional, and then it would have immediately kicked to the Supreme Court. I think the thing that most of us following this realize is that this decision, the way it was structured, as Katie just described, it probably moves us to a world where this moving to the Supreme Court now becomes later than sooner. With the caveat, we have to see how Attorney General Becerra of California's request plays out. What is critical to this is how, on the political side, is how it plays in the next election. As we see issues related to both the Affordable Care Act, your health care, pre-existing conditions, the Medicaid expansion, everything that is tied into the Affordable Care Act on the table, along with the critical importance of the Supreme Court. Now, is that a issue that is hot and live in 2020, in the spring, in the summer, in the fall? This decision may have kicked that outside of it. And that will be what we'll watch to form in the next days, weeks to come, especially on the timing. If Becerra is granted and the Supreme Court takes it up, it makes it very hot. But if the Supreme Court says, pass, go work it out, we'll be here when you get to us, then it goes to the 5th District. Goodness knows how long that takes out. And it will just be a different level of, again, how hot it is politically.
Great. Thank you, Rodney. So let me jump in a little bit more on this timing question, and Katie, we had been chatting about this last week, and this was a sort of course of action that you actually kind of had predicted in terms of a remand back to the district court and sort of a splitting the middle kind of a decision. Do you see this largely as a decision to push back the timing of any kind of a Supreme decision, or what is your prediction as far as what the Supreme Court will do, and how do you see that timing play out?
Yeah, it's a great question. So this is one of those instances where you can't always predict what a court's going to do based on oral argument, but it just seemed, having kind of closely followed the July hearing, the panel asked multiple times, why shouldn't we send this back down? And here I would emphasize, I think a lot of this was created by the confusion from the Department of Justice that, sort of took one position to start, then kind of wholeheartedly agreed with the plaintiffs. They followed up by saying they think the entire ACA should be invalid, but only the provisions that affect the plaintiffs. And then even a week before oral argument sort of seemed to suggest that the ruling should only apply in the 18 plaintiff states and to the 2 individuals. And so during the hearing, you could really hear the panel grappling with this. So in many ways, I'm kind of not surprised that this was the tack that they took to sort of send it back. I do think a lot of this sort of blame for this confusion maybe sits with the Department of Justice and the Trump administration. That said, the dissent in the Fifth Circuit by Judge Gaynes, she makes a really compelling argument that the Fifth Circuit easily could have decided this case, and that severability is sort of a no-brainer here, which is, again, a view I think shared by many conservative legal scholars as well, that it's pretty clear what Congress was doing. When they sort of zeroed out the individual mandate penalty, they left the rest of the ACA in place. They had tried for a year to repeal broader parts of the law and failed. We know exactly what they were thinking. There's no reason to sort of try to see what they were intending, because they did what they meant, which was only to eliminate the penalty and nothing more. So she sort of takes her colleagues to task to say, we should have just decided this. There's no need to remand. Sarah, I think that gets to your question of, is this sort of a delay tactic to send it back down to OConnor? I would also venture, I think, I follow many, many cases before Judge O'Connor on the ACA, and I don't know that he might explain his reasoning better, but I don't know that he will deliver a different substantive decision to the Fifth Circuit to review once again. And so that's something to watch as well. If that's the case, if we're just waiting on Judge O'Connor to issue a very similar opinion, it does feel, and seem like a delay tactic. I think all of these are reasons that the Supreme Court sort of should take this up and address it. I agree with Rodney that many of these ACA issues are sort of unsettled until the Supreme Court says so, and sort of, I think Rodney said, put this foot down. And so the idea that we would allow this case to be remanded back to Judge O'Connor, that would be many months at least process for him to reconsider, go provision by provision on severability, issue a new decision. That would go up to the Fifth Circuit. That would take more months. And then you would have this go back up to the Supreme Court. I mean, we're looking at multiple years of uncertainty based on the individual mandate itself. And so, there's a part of me that thinks the Supreme Court, there might not be, I think there should be personally, but there might not be enough urgency for them to take it up this term and really expedite the briefing. But there should be, because this is such a critical question, and it really is sort of hanging over the entire healthcare industry and patients.
Thanks, Kate. Let me ask you a couple quick follow-up questions. One, technically speaking, how many Supreme Court justices have to agree to take up a case in order to make it so?
4. Yeah, great question. So 4 justices have to agree that have to approve the request for a cert petition. So you could see a world in which any combination of the justices, but there's a universe in which the sort of liberal justices, air quote, want to see this go up, or the conservative justices, that kind of thing. I think there's probably enough votes to get this up to the Supreme Court. The timing, I think, is the real question. And does, having a Fifth Circuit decision that remands the case, does that give the Supreme Court enough cover to deny the cert petition and just say, we are going to take this up at some point, but we're going to wait for it, we're going to wait for it to move back through the process once again.
Thanks.
So again, jumping in as the nasty political person in the conversation, that if people are looking at the decision and saying that the Fifth Circuit got to have its cake and eat it too, to both, to declare it unconstitutional, but remand it back to the district to slow down the process to make it less politically toxic, that the four left-leaning members on the Supreme Court have at their disposal to say, no, you don't, and rule in favor of Becerra's motion. Would that be fair to say, Katie?
I think that's right. I think it comes down to timing. So whether it comes up this term or next term, but you're right. It's four justices. You could see that coming from multiple different places on the court, perhaps.
Well, thankfully, we do not have a heavily politicized judiciary that we have to worry about things like that happening. So all good.
All right, we have a couple of questions from the audience, and one asks and I'll ask Katie to start here. More specifically, what exactly does the remand process look like? The questioner says that they recall that in the NFIB case oral arguments, Chief Justice Roberts at one point asked, what am I supposed to do? Appoint a special master to go through the ACA line by line and determine which pieces should be stricken and which not. So this kind of goes to the severability question as well. Do you think this is what the district court will now essentially do? Will they take up the sort of fine-tooth comb directive of the Fifth Circuit?
That is certainly what Judge O'Connor has been directed to do. I don't know if that is what he will do. He tends to do what he wants pretty regularly. And I will give the caveat, I'm not a litigator, but sometimes I play one on TV. So my understanding is that essentially that Judge O'Connor, the remand process could even sort of proceed. This could go back to Judge O'Connor and he could begin that provision by provision analysis on severability, even as California, files its cert petition with the Supreme Court. So we might, for a little while, at least have a parallel process till we hear from the Supreme Court. I don't know exactly what that would look like, and he would Judge O'Connor would, I'm sure, set up a briefing schedule and bring the parties back together. I think it'll also be interesting to watch to see, beyond just kind of severability, how does he deal with some of the issues raised by the Department of Justice with new positions as well? Does he really take on this? There's a possibility that this would apply in only the 18 plaintiff states. Does he grapple with that at all? All of those types of questions. So, again, if you're going provision by provision, that could be a long process. Judge O'Connor has his own method, put it that way.
So let's get a little more specific about the severability question and what exactly we think might happen. So, this relates to a question from the audience about sort of O'Connor's analysis of pre-existing conditions. And do we think that if the tax falls, if the individual mandate falls, then those protections will fall as well? Essentially, how far could the decision go? Obviously, last time the judge decided to strike down the whole ACA. Do we think it'll go back to just the sort of the Title I protections, and then how much of the Title I of the ACA would it be the pre-existing conditions and the subsidies, pre-existing conditions, subsidies, and Medicaid expansion? Can we talk a little bit about, and I know it's hard to look into a crystal ball, but maybe get a little bit into the implications of each of those.
Sure. So my sense is Judge O'Connor would probably reissue a severability ruling as broad as possible. I don't, given his other decisions and his approach to this case so far, I don't see anything about that approach that sort of counsels judicial restraint on severability. I do think he will be more constrained as a result of this Fifth Circuit decision, but it's even because of some of the ways that the Fifth Circuit ruled on this, I think it will be difficult for him to just strike ad hoc, Title I of the ACA or something like that. So there was a part of the Fifth Circuit's decision. Again, they said good things about his analysis on whether the pre-existing condition protections should fall with the mandate. They seem to sort of like that part of the analysis, but they specifically asked why in the world did the menu labeling provisions of the ACA fall alongside the mandate? And then they pointed to other items in Title I that went into effect before the mandate did, so sort of calling out some of those early market reforms that folks might remember went into effect in 2010, things like the ban on lifetime limits, independent coverage to 26, and sort of arguing, these aren't at all dependent on the mandate because they went into effect 4 years before the mandate ever did. And so those are some of the examples that the Fifth Circuit kind of teases out in its opinion. It isn't so explicit to say we're making a ruling, and they do go out of their way to say that the outcome is not predetermined. So they really did leave it wide open to Judge O'Connor's discretion. They just want him to explain himself better. And again, knowing him and some of his other rulings, I would expect him to go as broadly as possible, which is not a satisfying answer to your question, but I think it's still something to watch.
Okay.
But I think, Katie, and I'm curious if you would agree with this. I mean, within the more conservative side of the jurists on the federal courts, I mean, there are a lot of folks who actually question the, frankly, more political decision that you saw Roberts lead in NFI versus Sebelius, not the least of which 4 of his more conservative colleagues on the Supreme Court who questioned the nature of his decision, and that arguably what you're seeing within the Fifth Circuit is the process where they are working on sending it back to him to say, did you really mean it? Because we don't agree with NFI versus Sebelius. We still don't agree with it. Would you like the opportunity to reconsider it?
Yeah, I think that's part of it. I will say that this majority of the Fifth Circuit pretty much wholeheartedly embraced, I think, the dissent in NFIB with, partially including the Chief Justice in that analysis. And so I do think they are all pushing, Judge O'Connor included, all pushing on the NFIB decision, where I think, this is a much clearer case, is on severability. Maybe reasonable minds could disagree about the mandate and whether it remains constitutional at this point, but on severability, this should not be happening. And I think Judge King's dissent makes a really strong point of, severability is a legal question, not sort of a factual question. And so why is the Fifth Circuit, or why is the district court in this case better equipped than the Fifth Circuit to be, doing this analysis? The Fifth Circuit could have decided this on its own now and allowed the case to move forward.
So let's ask this question about, and this is from the audience, that if Congress and or a new Democratic president restored the penalty, would this make the decision moot? And another person asked even if it was reinstituted at $1. Does the whole thing go away? What is at the disposal of Congress right now in terms of policy? But then, I'll ask both of you in terms of policy, but then, in terms of the political realities as well. Katie, do you want to start us off with that?
Sure. So the idea that Congress could come in and, add $1 or strike the actual text of the mandate itself so that you don't have a mandate without a penalty, I do think all of that would moot the case. This is really it is this one change in the Tax Cuts and Jobs Act to zero out the penalty that all of this hinges on. And there was a moment, I don't believe it came up at the Fifth Circuit oral argument, but the district court hearing before O'Connor where one of the parties was, pushed on whether a new Congress could come in and just increase the penalty, and wouldn't that make all of this go away? And they admitted yes, that would be the case. And so there's there are certainly, I think, options on the table for that, and potentially a role for Congress to play, assuming that would work. And I would turn that over to Rodney. I think there is some danger in Congress fiddling with the legislation now, or perhaps introducing bills to try to save the mandate, if there's the real possibility, and I think there is, that bill would not become law. So you could see bills being introduced to increase the penalty, for instance, at this point, contributing to the litigation as sort of evidence of Congress's intent that, there is a problem here. Whereas if you don't try to fix it right now, you can kind of move things along and say nothing to see here. So
and
any thoughts on that? Yeah, go ahead.
And I think it's fair to say that it is extraordinarily unlikely that any such law will pass before November of 2020. However, in as much as we believe that this is A, still a live case, and B, have an electoral outcome in this direction, I could see that legislation passing on January 20th of 2021.
So let me go to some of the policy questions, because this question about the individual mandate, this consumed the presidential campaigns pre-ACA. There was a lot of argument about it. How important was it to have an individual mandate in order to from a truly practical perspective, ensure that there was the conversation about a three-legged stool of, you had to have an individual mandate, everybody had to buy coverage if you were going to have pre-existing condition protections, and then if you were going to have the two of those and require somebody to buy insurance in order to, make the market work properly for everybody, including those with pre-existing conditions, then, you had to have the subsidies to help people who couldn't afford the coverage. What have we learned in 10 years about, whether the individual mandate truly is necessary for this, and can the markets kind of function, if not as well, can the market still kind of function somewhat as well without it, or are there alternatives? We've gone from a theoretical conversation to a more experience-based conversation. Rodney, what do you think?
It's fascinating that we're in the middle of a real-world economic experiment here. We all believed very strongly back a decade ago that the three-legged stool required one leg that said, hey, we got to make people participate. If we let the young immortals get out, then the whole thing collapses. We did so, I will recall, and Sarah will recall as well, largely at the behest of the Congressional Budget Office, who deeply believed in that theory. But now it doesn't exist anymore. It didn't exist. It did exist on day one. And so our experiment is, first, you had it, and it caused participation. You had the market develop. You had the market stabilize. We can argue over just how stable it is to this moment, but it has stabilized enough, and now we've kicked out the leg. And we know the numbers from last year. We'll very soon see the enrollment numbers from this year. And this is an experiment ongoing, that once you have this market in place, once insurers figure out how to operate in this marketplace in a way that is stable, that the premium shifts are not draconian up and down like a sine wave, that as you are stable, is the actual need for a leg that causes participation absolutely necessary? And we're in a process of a real-world economic experiment to learn that answer.
Thanks. And Katie, I don't know if you could comment, but also to comment on what the states are doing. Some states have instituted their own individual mandates or have been thinking about that. Does the ruling affect that? What do you think states are going to do?
Yeah, well, I would start by saying I agree with Rodney, and this comes up in the decision as well. California kind of made this argument early on that it's sort of it's a new world. So the mandate is less, if the question on severability is if the mandate so essential to the functioning of the rest of the law, I think Congress arguably knew, and the answer is no. But in passing the Tax Cuts and Jobs Act, they had the CBO data. It showed 4 million more people would be uninsured, but it wasn't sort of this devastating impact. Congress, used that information and acted on it. And so I think it does speak very much to Rodney's point that we're seeing this play out, but Congress also used the judgment to make that decision and say we're not so worried about this. Clearly, the law can stand without it. Judge King in her dissent sort of walks through this as well, that you have to think about this change in a post 2017 world, not as what Judge O'Connor did in, what the Congress of 2010 would be thinking about the individual mandate and would they have ever thought this experiment would be working out the way that it has. So those are, I think, are two issues to pay attention to. In terms of states adopting their own mandate, this is sort of going to continue to play out. I think one point of caution, clearly under Judge O'Connor's ruling, states are limited in their ability to fill in gaps. So even if you solely look at the loss of, hundreds of billions of dollars in federal ACA funding from Medicaid expansion and marketplace subsidies and all kinds of other programs like the Prevention and Public Health Fund, let's say, there is a sort of narrow universe, and I'm using narrow with air quotes because it would still be a pretty significant ruling, but if the court only sort of struck down, the pre-existing condition protections or parts of Title I, there is a universe in which states could fill in some of those gaps, as we have seen them do by, for instance, passing their own mandate. But I don't think there's many ways for states to sort of legislate their way out of this one if the court comes back with a ruling anywhere near as broad as what I think we all expect it to be. So I think states are, will continue to have kind of flexibility to make their markets work for them, but I would really give a word of caution that states are not going to be able to dig themselves out of a hole necessarily.
Thanks, Katie. All right, so we've got another policy question from the audience, and then a couple more that deal with some more Supreme Court sort of process issues, and we have less than 10 minutes left in the webinar, so we're going to try to cover all of that as much as we can. One questioner asks, what does this mean, or could this mean for Medicaid expansion? And what's the risk for beneficiaries and for states that opted in? Rodney, you want to take a step back?
Sure. I mean, again, that this effectively, NFIB versus Sebelius said the Medicaid expansion as written was unconstitutional. So states were not required to expand. So instead what we have is a state option to expand to the population in the Affordable Care Act and do so at a rate established in the Affordable Care Act. How that has anything to do with the individual mandate is going to be back in Judge O'Connor's ballpark to determine, but none of us should treat that as in any way imminent to making changes until we see this before the Supreme Court and hints that John Roberts might be willing to go back on the political decision he led in 2012. For states, again, I doubt that any of the states that have yet to expand are sitting there looking at this case going, well, we should be careful, it might not be there. They have plenty of other reasons politically not to have made that call by this point.
All right, so let's go to the couple more questions about the Supreme Court, and I want to make sure to address sort of questions about perhaps some of the most extreme scenario, of which we have had a couple. What if the Supreme Court does strike down the law in its entirety? Do we think that would happen? And if so, would there be some kind of a phase-down period? Like, what happens in that scenario? Cats
and dogs living together, mass hysteria. We speculated on King versus Burwell and what would happen then. We speculated on NFIB versus Sebelius, but at least that was the point that it hadn't fully gone into effect at that stage. It's just hard to imagine the political world how it would put Humpty Dumpty back together again at that point. And as we've watched this week, in which we are watching 3 tax pieces that were part of the law go bye-bye. And so with every moment like that, it does get harder to imagine if that was actually the case. I have no clue how you'd put Humpty Dumpty back together again.
Katie, you talked about earlier that 4 justices could accept the case but require it to be heard this term. We had a clarifying question about if they did that and it was heard this term. Do you have any idea of what the timing would be? Would that be pre-election of 2020 or post or what?
I think it would. I'm pretty sure the Supreme Court can do what it wants. Let me just start by saying that. But, my anticipation, if they were to take it this term, they would set oral argument for some time in kind of perhaps a March, April timeframe. They would have a very collapsed briefing schedule that the parties would, need to respond to very quickly, and they would still sort of issue a decision by the end of sort of June 2020, when they typically issue many of their blockbuster decisions. I guess one additional point on sort of your previous question, Sarah, about what would happen if the whole thing goes away, and how likely is it that the Supreme Court would do that. I think under the current Supreme Court and the 9 justices who are seated now, I worry a little bit less about a big, dramatic, devastating ruling. I do worry about, maybe something more in the middle, parts of Title I or other parts of the ACA, but I think it's less likely that the whole thing goes down. One concern perhaps about waiting and, shifting and allowing the case to move to the next term or potentially down the road even further if the case is remanded back to Judge O'Connor, is that you might have a new court, and we don't know exactly how a new court or a new justice would view this type of lawsuit. So to me, I'm a little bit like Rodney too. I don't want to speculate, but it brings me more concern than it might for others.
But since we're speculating, Katie, just for fun here, I want to follow on something you just said, which is if 4 justices, let's say led by the left side of the courts, agreed with Becerra and asked to move the case to the Supreme Court, it's still up to Supreme Court Justice, Chief Justice Roberts to determine whether or not it goes on the fast track. And would one assume that if it got put on the fast track, could that be because Chief Justice Roberts is looking at this going, this is crazy pants wrong, and let's just get it over with? I just leave that out there as something to speculate on for fun, since that's what we're doing over popcorn.
All right, well, and I'm going to ask the question of, since we're in the season of peace on earth and goodwill, what, if anything, would a more extreme ruling mean in terms of, would that finally force some kind of bipartisan action on this, or would we just simply go back to the days of kind of pre-ACA politics and start all over again? Ronnie, you're laughing at me.
Oh, bless your little heart. You said bipartisan action out loud. Like you actually meant it. Certainly not before the 2020 election, and I'm not certain where the 2020 election leaves us. I am somebody who I consider myself as cynical as the next person. I can be glass half full of battery acid as needed, but I was actually rather shocked that the 2012 election didn't lead to some sort of detente. And so it's really hard to imagine this next election leading to detente as well.
All right. Well, one last question from our audience, and as we wrap up, given the scenario, the ACA is still the law of the land for now, but there's still this uncertainty that's out there in terms of timing, in terms of what the courts might do. Somebody asks us, how do folks explain what is going on to consumers? Do you tell them, your insurance is still protected pending the litigation? How do you think the industry and others who are trying to reach patients and consumers should be messaging this?
Yeah, I do think this is a big concern. I think we're, on the heels of the extension of this year's open enrollment period for healthcare.gov. You also have many state-based marketplaces that are still open for enrollment. This was a big focus of AG Becerra's comments yesterday at a press conference. I think the messaging to patients and real people and folks who rely on the ACA for their coverage in particular has to be, nothing is changing immediately. Folks should still pay their premiums. They should still expect their coverage to be there. If anything were to happen, I think there would be kind of a long lead time, and hopefully no one sort of gets the rug pulled out from under them. Again, I think there shouldn't be this uncertainty, and that might argue in favor of the Supreme Court taking this up more quickly than it should. But I think for real people, real patients and consumers, it has to be that nothing is changing in the immediate future.
Yeah, we are open for business, and no one should read anything else into this decision or any decision until we are at the Supreme Court and you look at Justice Roberts and he's starting to give you signals that, he might have changed his mind. We are open for business, and no one should treat it as anything different.
Well, on that note, we are open for business, and this is now the final Alliance event or briefing of the year and of the decade. So I thank you, Katie and Rodney, for joining us today and sharing your thoughts. Definitely to be continued. I thank everybody for joining us on today's webinar. And thank you again to the NICM Foundation. So that concludes our webinar. Hope everybody has a happy and healthy holiday season.